So for the next speaker, we are pleased to welcome Mr. Alexis Merle, a practicing barrister in law and the founder of Merle Practice in Mauritius, specializing in civil and criminal law. He holds advanced legal qualification from esteemed institutions in France, Ireland, and the United Kingdom, and is called to the bar in both England and Wales and Mauritius. Mr. Merle currently serves as the registrar of the Mediation and Arbitration Center Mauritius Limited, where he plays a pivotal role in administering area proceedings and promoting best practices. His active involvement in international arbitration bodies and his leadership in regional area development make him a valuable voice in the field. We invite Mr. Alexis Merle to share his insights on ADR in Mauritius and to contribute to today's dialogue. Over to you, sir.
Thank you very much for the kind invitation, and good morning or good afternoon to everyone watching us today, depending on wherever you are in the world. It's a pleasure for me to be able to discuss about how ADR, arbitration and mediation has evolved and is currently doing in Mauritius. So I think maybe if I can start with giving you a brief history about the country itself, so you can have an idea of how we came up with the laws that we do have here in Mauritius, because Mauritius was actually first really colonized by the French and then by the British. So in Mauritius, we have a very interesting hybrid system of law, where most of our substantive laws will be based on French law, so the Code de Napoléon, and a lot of our laws which deals with company law, for example, and administrative law will be based on English common law. So this is a very interesting part of our legal system, because this is where our ADR will play a role, and where our ADR actually came to light. So unlike in Tanzania, like Madeline just said, that where they have an arbitration act which cater for both domestic and international, in Mauritius we currently have an arbitration act which cater for only the domestic arbitrations, and the International Arbitration Act which will cater for international arbitrations. So our domestic arbitration rules will be based on our civil procedural code, which is based on the Code de Napoléon. So maybe one thing that we could be looking at our day is it still relevant? One may ask, is it still relevant to have two different kinds of legal framework for arbitrations in Mauritius? But our domestic arbitration is mainly based, therefore, on French civil law. And then the government enacted in 2008 the International Arbitration Act. And the International Arbitration Act, which is based on the UNCITRAL model law. So we have these two different legal framework that we use in Mauritius, which is kind of a bit of inheritance from our history. One thing maybe it would be good to know as well is that even if you have a domestic dispute under the International Arbitration Act, you are able as parties, if you have obviously a consent of both parties, to have the International Arbitration Act to be applied to your domestic arbitration. So you still have the option to opt in and have the International Arbitration Act applying to your dispute. So in Mauritius, in terms of institutions, I am currently the registrar of the Mediation and Arbitration Center of Mauritius, which is also called the MARC. So the story about the MARC, it essentially came up with the Mauritius Chamber of Commerce and Industry. And the Mauritius Chamber of Commerce and Industry dates back to 1850. And the first registered arbitration case in Mauritius under the Mauritius Chamber of Commerce and Industry dates back to 1855. So we have a very long-standing management and administration of arbitral disputes for almost 2 centuries now. And since 1850, the center evolved. It used to be under the aegis of the Mauritius Chamber of Commerce and Industry. And then it was rebranded in 2014 as the MARC. And it really revamped its organizational structure in 2017. In 2017, the institution created a MARC court and a MARC advisory board. The role of the MARC court is to deal with prima facie decisions, such as, for example, if the parties cannot agree on the number of arbitrators, it will be for the MARC court to decide. If the parties cannot agree on the arbitrator or the arbitral tribunal, then it's going to be the MARC court who will have to decide. The MARC court is currently composed of 17 eminent experts, and which is currently presided by Neil Kaplan, which is King's Counsel. Apologies for that. Can you hear me, Imba?
So you're audible.
Sorry, there was a bug. There was an issue. So we do have the MARC court. We have representatives from all over the world. We have members such as Lord Neuberger, Achille Ngwanza, Arthur Ma, Yves Fautier, David Rifkin on the board. And we also have the MARC advisory board. The MARC advisory board is also composed of 17 experts, but their role is to promote and assist the MARC secretariat to better promote the use of ADR. So since 2017, the aim and the intention was really to give an international perspective to ADR. And this was actually the intention of the government since 2008, when the International Arbitration Act was enacted. One maybe particularity of our International Arbitration Act is the cooperation or collaboration that Mauritius does have with the Permanent Court of Arbitration, which is based in The Hague. If you look at our International Arbitration Act, the appointing body is the PCA, the Permanent Court of Arbitration. The PCA also had their first sub-office in Mauritius, and they've recently celebrated the 25th anniversary of their sub-office here in Mauritius. So basically in Mauritius, we have 3 arbitral institutions, the MARC, which I just presented. There is also the MIAC, which is the Mauritius International Arbitration Center, which was formerly known as the LCIA MIAC, but became a fully independent center in 2018. And it is currently located and share the same offices as the PCA sub-office here in Mauritius. Maybe now if I can turn and keep on giving some insights about our legal framework. I've mentioned the International Arbitration Act, which is based on the model law. We are also a signatory, obviously, of the New York Convention. And we have the no reciprocity reservation, so awards from any foreign states are enforceable here in Mauritius. We do have, since 2013, established the Supreme Court rules on international arbitration. And one of its specificity, which was a very commendable effort, was to have a panel of specialized judges of the Supreme Court who would have obviously received extensive training in arbitration matters, and they have now been earmarked as the panel of experts, the designated judges, who will be the one appointed when dealing with any matters concerning international arbitrations, either it is for setting aside or enforcement of arbitral awards. So we do have this process here and specificity here in Mauritius. The aim of it was to be able to deal with arbitration matters and disputes in a more efficient way before our courts. So this was the intention of the legislature back in 2013. As I mentioned, we also have the Code de procédure civile for domestic awards. But I think, in my personal opinion, it is maybe time to reconsider and have both acts a unified maybe legal framework, because we've seen recently in cases, in domestic cases, that the current legal framework concerning our Domestic Arbitration Act is currently lacking. There are some issues regarding the Act. Maybe if I can give one example, there was a recent case, the case of lateral holdings against China Jiangsu, which concerned a domestic arbitration, which was conducted ad hoc. And it took more than 7 years for the arbitration to not even be over with, because as per our Code de procédure civile in Mauritius, every 6 months, the mandate of the arbitrator has to be renewed. And after 7 years, one of the party did not renew the mandate of the arbitrator, and the arbitrator did not give his arbitral award. So after 7 years, both parties were back to square one. So I think, in my personal opinion, in order to avoid these types of issue, maybe if we have a unified arbitration act, this would be able to solve such matters and give more incentives to the business users and economic operators here in Mauritius to use arbitration, give them more confidence into the system. Maybe one point, I will try to stay on time. I promise him that I will. I would like to touch about is that we've been discussing a lot about arbitration, but I think mediation should be something that is as important as arbitration. And this is maybe one of the challenges that we do have here in Mauritius. As at date, we still do not have a mediation legal framework. Although Mauritius had signed the Singapore Convention, but it is yet to ratify it. Mediation is getting more and more popularity, and I think it is about time that the country thinks about having and incorporating mediation legal framework. On a very positive note, a few months ago, the newly elected government made a speech and talked about the intention to bring back Mauritius on the international stage for resolving alternative dispute resolutions. So this is a matter that the current government is definitely looking into. As recent developments regarding our legislative frameworks and ADR, the current Attorney General has mentioned that he intend as a reform to have a new Supreme Court Court of Appeal system here in Mauritius, which will deal with arbitral disputes and matters. Once again, the aim is to give more confidence and to be more efficient regarding the administration of appeals to, not appeals, but for application for setting aside or enforcing arbitral awards here in Mauritius. So there is definitely a will to amend things, and I think to be inspired on what is currently being done in the UK, what has been done, for example, in other countries such as Germany or Singapore, and even Bahrain, which recently have partnered with the Singapore International Commercial Court. So I think the current government is really looking into the matter to amend the current situation and to make things more efficient. Imba, maybe if I may as well, I don't know if I still have a lot of time. I would like to discuss about maybe a landmark case, a very recent case, the case of Laporte and Laporte, which judgment was recently delivered by the Supreme Court of Mauritius in February 2025. The interesting part, and why I want to mention this case, is because the case deals with the issue of security for costs. So the main point in dispute was the need to provide suitable security under Article 6 of the New York Convention when enforcement proceedings are stayed. So it was about security for costs in relation to an appeal to the Judicial Committee of the Privy Council under the Supreme Court rules. So just to give an explanation how the Judicial Committee of Privy Council is in the picture, is because in Mauritius, our last Court of Appeal remains the Judicial Committee of the Privy Council. So decisions from the Supreme Court and the Court of Appeal of the Supreme Court can be appealed to the Judicial Committee of the Privy Council, which was the case in the Laporte case. So in fact, in this case, the dispute arose from an arbitral award, which was actually administered by the MARC. This arbitral award was rendered in favor of Mr. Eric Laporte, and the proceedings were seated here at the MARC in Mauritius. The respondent, who was his brother, so Mr. Marc Laporte, sought to set aside the award and resisted its enforcement. But after his application to set aside the award was dismissed, he appealed to the Judicial Committee of the Privy Council. So the Supreme Court put the enforcement proceedings in abeyance pending the appeal and actually ordered Mr. Laporte to provide security by way of a bank guarantee for the full sum of the award under Article 6 of the New York Convention, and to pay security for costs to be incurred in the appeal to the Judicial Committee of the Privy Council. So the interesting part about this judgment is once again the pro-arbitration stance of the judges here in Mauritius by enforcing and applying Article 6 of the New York Convention when a party has applied for security for costs. And the interesting part is that it was for the full sum of the award and even for the cost to be incurred in the appeal to the Judicial Committee of the Privy Council. So it was the first time that our Supreme Court judges had to make a judgment about such a specific issue regarding the security for costs. So this was the case I wanted to bring on. Now, regarding maybe the current challenges and not issues, but yeah, let's say challenges to ADR here in Mauritius. I think we can separate it in two phases, and I think this challenge may be similar to in every other country actually. It's the need for, we need to have awareness. I think the main thing about ADR and users of ADR is creating the awareness on how useful and appropriate these measures are. So in Mauritius, the culture of people litigating have always been to go to court, but recently there's been a trend, and economic operators and other users are starting to realize the benefits of having recourse to mediation and arbitration. And it can clearly shows in the statistics. We're having more and more cases, either whether international or domestic as well. But there is a real need to recreate that awareness, but regarding mediation as well. So for arbitration, things are going well. Obviously, there are always things that can be done to better the system. But currently, I think there is a need for mediation. Madeleine also talked about mediation, having only received a few cases and administered a few cases, a few mediation cases. The situation is similar here in Mauritius. Mark has administered a lot more arbitration disputes than mediation disputes. But I think the one way to be able to better promote the use of mediation would first to start with enacting a mediation legal framework. So maybe this is something that the newly elected government will be thinking about, and hopefully we will be able to see new changes and amendments made to better the mediation system here in Mauritius. So unless you have other questions that you would like me to answer or interact with, or if anyone has any questions about the jurisdictions in Mauritius, please feel free to reach out. I think I've kept to my word. I think I was given 15 minutes, and I think I should be within that timeline.
Thank you, Alex. It is a wonderful experience, what I had when I met you in Mauritius. That continuation I could see. It's a combination of the French and the British legacy in Mauritius, which led to the level of even Mauritius becoming one of the hub in the African continent, making it to be an effective gateway for not only when it comes to tourism. Mauritius also eventually facilitated multiple international arbitrations, particularly investment arbitrations. And that legacy is still continuing. And the task given to institution like yours, wherein you are the registrar, MARC, the Permanent Court of Arbitration of the Mauritius Chamber of Commerce Industry, and other institutions in and around Mauritius. We are grateful that your insight on the arbitration regime in Mauritius, which also has the advantage of bilingual, very interesting thing for international arbitration stakeholders wanted to have, whether it is going to be the French facilitated arbitration or the English language facilitated arbitration. Mauritius is the destination and the seat predominantly what we need to have. Alex, as one interesting thing I wanted to know on behalf of the entire participants, to what extent this Mauritius courts, when it comes to enforcement of the foreign seated arbitral awards, any interesting phenomenons which you want to share here?
Yes. So regarding enforcement of foreign arbitral awards, as I've mentioned, we do have signed the New York Convention, and we have the law which transcribe foreign arbitral awards here in Mauritius. And also, as I mentioned, Mauritius does not look at reciprocity when enforcing foreign arbitral awards. One international award which was rendered, which maybe is the famous case of Betamax, that a lot of people might have heard of. That once again, this case showed that it talked about basically the public policy. That was the entire arguments which was argued before our courts. But the interesting fact about it is that Mauritius, regarding enforcement of foreign arbitral award, have always been a pro-arbitration stance. So as you have highlighted, where we are in Mauritius, we are at the crossroad of the African continent and the Asiatic continent. So I think from the legal framework that we have, the International Financial Center that we do have here in Mauritius, I think all the ingredients are united here to be able to be the most preferred seat in the region. You know, usually when parties, especially in international commercial disputes or contracts, if you have one party coming from, let's say, China and investing in South Africa, usually the party in South Africa will not want his disputes to be resolved in China, and the Chinese parties, vice versa. And I think this is what attracted and made Mauritius a real hub, is that a lot of users have found out that Mauritius is actually equipped with all the legislative framework to be able to handle these type of dispute as an independent arbitral seat. So we have all the ingredients here, and I think maybe that's why we are where we are now on the arbitral scene. One very famous event, ICA, was even hosted here in Mauritius back in 2016, and obviously the bilingual aspect of it plays a very important role, because we are able to administer disputes both in French and in English, but also the fact that our hybrid system is based on French civil law and English common law. We are also well versed in our legal system here to adapt to different disputes coming from all over the world.
Thank you, Alex. Hope Mauritius is going to be a valuable resource for the Global South, and we hope the effective one should be there in the coming years. Thank you, Alex, for joining and sharing your valuable points.
Thank you very much, Imba, for your invitation. Much appreciated, and we will definitely be in touch with the Global South for sure.
Sure. Thank you.